I'm an attorney with the Geraci law firm. We are a 12-person or 12-attorney law firm out in Irvine, California. We're just a real estate law firm. We don't do anything else. And we kind of consider ourselves experts in that field. Margaret invited me here to speak today. I spoke at another event. And a lot of times I get hit with questions. And the number one question is, why do people end up in lawsuits, right? And so most of the time, they're frivolous, right? And if you've actually seen the statistics on it, 98% of cases settle. There's a reason for that, because most of the time there's no actual underlying dispute. There's really just someone that's upset with the other person, and inevitably they feel wrong for whatever reason. But I'm here today to talk about that 2% because it's really relevant, and most of the time it's prevention that could have stopped us from getting to that 2%. So just a little bit about the law firm itself, kind of some of the things that we do. We practice litigation, broker defense. We prepare custom documents of all kinds, so any sort of real estate transaction, whether it's deeds of trust, tenant in common agreements, any sort of custom loan documentation, basic loan documentation as well, any sort of agreements that brokers generally enter into, so agency agreements, independent contractor agreements, servicing agreements. Any gambit within real estate itself, I'd say we're pretty competent in. But I want to kind of branch into a quick segue here. So I'm going to get us back into real estate law, which many of you had to take. So what are the 4 elements of a contract? Feel free to just throw it out at me. What's the first element of any contract?
Written. Intent.
Offer.
Offer. Great. What's the second element?
Acceptance.
Okay. Doing good. Third?
Terms.
So that's one way to phrase it. What else? That's another?
Conditions.
Consideration.
Consideration. Great. What's the last one?
Signature.
Say it again.
Signature. Sign.
Executed? Executed.
Get in there. This one is my favorite one. So,
Competence.
meeting of the minds. What does that mean? What does it mean to meet of the mind? To have a meeting of the minds? Because that's where the 2% fails. When I see a legitimate dispute, there isn't a meeting of the minds. One party thinks A, the other party thinks B, and they've both entered into a contract which says C. And that's where you end up with almost all of the disputes that we actually sit back and have to litigate over. So let's talk about kind of some examples of where you're going to see a meeting of the minds issue. So, and I'll just bring a current example of what our law firm is dealing with, right? We have a referral agreement. Broker refers loans to lender. It's an exclusive agreement. We're in a commercial context, so we're not worried about referral fees in this context. So what the lenders agreed to is, you need to bring all of your loans to me first, and I will provide you terms. If the borrower doesn't want those terms, then feel free to go elsewhere, but you must bring them all first to me, right? Part of that agreement states that there's no profit sharing involved. These two, the referring broker and the lender, they're not to share in profits with one another. So where's the dispute? That broker applied for a loan from the lender. He got his referral fee for doing so, right? But the actual loan itself included a profit sharing component to it, right? And so the broker is now saying, wait, your agreement said we are not to share in the profits. And the lender says, wait, no, we're not sharing in the profits from the loan that you give me. All you get from our agreements is I give you a referral fee, and I get to enter any kind of loan that I want, right? There's a legitimate dispute there. And what you have is you have 2 contracts that say different things that are in dispute with one another. And that's kind of a summary of all the things that I see happen that go wrong in this. There tends to be a failure to understand one another's position. And the bigger problem you face is when people get down to the contracts, they weren't properly drafted, right? Because if it was properly drafted, this would have never occurred in the first place, right? You would have 2 contracts that match each other. But a lot of times what happens is people come in and say, I want an agreement, I want X agreement, right? I want a broker referral agreement, right? And they get that done. And then they go online and they find, and they have their own set of loan documents to use, or whatever it may be. They have another source. And they don't go to the same source to get their loan documents done or that secondary agreement done. And so what happens is you have 2 people that drafted 2 different documents that end up very different. And there's really no one to blame at that point, because you didn't have a meeting of the minds when it came to drafting the actual documents, right? So, this has really a strong matter of relevance to kind of what you do on a daily basis, because it was actually really interesting for me to watch the code of ethics up here, because I feel like meeting of the minds is the flip side of misrepresentation, right? And as I was watching the screen on here, almost every single one of the code of ethics that everyone is bound by have to deal with disclosure and representations, right? And so when you're sitting there and as a practical matter, you need to be very conscious of what you're saying and what you're not saying. Because lots of times you'll make statements without thinking about what the relevance of those statements are. And the person listening to them is making assumptions on those statements. And what ends up happening is what we just discussed. There's a failure to have a meeting of the minds. People have different conclusions about what's being said. And where this becomes really relevant, and especially in the context of what you're doing on a day-to-day basis, is there's a failure to disclose, right? And that's the number one broker dispute that I see on my side, right? And most of the time when there's any sort of broker disputes, it's because the person never truly disclosed to the other person, and it's not necessarily ill intent. There's just a failure to just state what they call material facts. And so let me give you an example of a case in which we're currently suing a broker over it. We had a lender come to us. He said, hey, I was approached by a broker, and he asked me, I've got a second trust deed available, right? The guy is selling it for $50,000. It has a value of $100,000. It's $50,000 profit for you. It's going to mature really soon. Slam dunk, you should take this, right? The dispute here in the situation is the lender is telling us that the broker never told him that the senior lien on that property was in default, right? Pretty material fact. So lender buys it. He buys it for $50,000, right? A week later, it's sold at foreclosure sale, right? How do you resolve a situation like that, right? It's he said, she said, basically. But here's the problem. As a broker, you're a fiduciary. You have to give all material facts to your principals, right? And in this instance, there's actual forms you would need to provide. So what this situation could have been easily resolved if the broker simply stated in his disclosures, the material facts of the loan. And there's a form, some of you may be familiar with it. It's the lender purchaser disclosure statement, right? So for you form people, it's RE 851A or RE 851B. And what that form is a material disclosure of all of the terms of the loan being sold, right? And so that's how that dispute, and quite frankly, that broker is toast. I mean, when you're dealing in a fiduciary context, a material omission is a problem, right? It's as good as making a poor representation at that point. So, that's one example right there. In terms of and just a quick show of hands here, how many of you actually help in providing finance for your clients? Okay. So this is an area that I see a lot of problems with, and it's a big area in terms of disclosures themselves. So, for those of you that do, there's two different primary forms that are used, right? There's the mortgage loan disclosure statement, right, which is either form RE882 or form RE885. You need to provide that to your borrower within 3 days. Your failure to provide that to your borrower is a sanctionable right there from the BRE perspective. Conversely, you also need to provide your lender with a lender purchaser disclosure statement, right? And what's great about these forms and what's great about all these sorts of disclosures is that they kind of provide a safe harbor, right? It helps you duck at that point. We're just saying, look, I complied with XYZ. The person made their own decision, and there's no longer a matter of a clash of a meeting of the minds at that point, because it's saying, I provided you disclosure, and at this point, you came to your own conclusion, right? And so you couldn't reasonably come to that conclusion because I provided you with the disclosure that I did. You couldn't, in this instance, let's go back to that example I gave you with the second trust deed. It was disclosed to you. You couldn't argue, you had now a duty as a lender to recognize that since you're in second, there could be a default, right? And so there's two things that I see coming up kind of in this context as well in terms of kind of issues that I see arising, and you're going to see, I think, more of this because the economy is in the situation that it's in, and interest rates are so low. So what you have right now is a great lending market, right? You have interest rates, well, at least for qualified borrowers. So you have a very low interest rate, right? And so, history will show us probably that this is going to be the lowest it's going to be, and 10 years from now we'll look back and say, wow, I can't believe we were getting 4.5% loans. But this is also the flip side of that I'm seeing currently at the law firm. I get calls pretty frequently now about seller carryback financing. Have any of you actually done a seller carryback financing loan for your sellers? Has anyone have any kind of, this is a quick question. How did it work out?
Perfect.
Perfect, right? Has the loan, what was the loan term? How many months was it for?
5 years.
5 years. When was it written?
December.
Okay. Someone got any hands raised?
Yeah, I did one for a 10-year loan that just, and it was 10 years ago.
Okay.
And it worked out perfect.
And it worked out perfect. Great. So I think that there's two ways to look at seller carryback financing. There's really great things. One, which is actually a really interesting thing that I came by when we just helped out a client. He actually was selling a $6.5 million property in Beverly Hills. Well, the problem is his basis for that was $800,000. So if he sold it for $6.5 million, that would have been a huge tax bill. And they were purposely selling it because they were in financial straits, so they couldn't just use a 1031 exchange. So they had real problems to deal with at that point. So what we ended up doing in that context is we did a seller carryback loan. It reduced his basis, and it amortized his payments over a period of 20 years. Right? We also made it so that the borrower could end up, that there was a stiff prepayment penalty involved. And so what ended up happening, even if the borrower planned on paying off early, our lender would have still been compensated for it. It's a great way to do it. But the problem I see is I deal with the litigation side of seller carrybacks a lot. And so what happens is, a lot of times they're too short of a duration. They're 1 year, they're 2 year. And chances are you're doing seller carryback financing because the borrower doesn't qualify for traditional financing. And the problem is in 1 year, they're still not going to qualify for traditional financing. And when you try to take someone's home from them, they're going to sue you. And so if you're going to enter in a seller carryback financing situation, you have to be really cautious about it. You really, and I always think of this, you've got to step away from the deal for a second. And you got to think about, is this going to work out, right? Because if you're only banking on the fact that, hey, this property is going to appreciate enough in 1 year, chances are that's not true, right? 10 years I like, 3 years is okay. I mean, you got to have some space in between these two events, because if you don't, chances are it's going to blow up. And who's going to get sued? You. Because they're going to say, my broker, my fiduciary, told me this was a great idea, right? And that's not, and you kind of do know better at that point, because it's kind of that concept of, hey, there's a reason this person couldn't qualify today, right? And so that's one thing. So seller carryback in and of itself is not necessarily a bad idea. If you're going to do it, I highly recommend getting legal advice to do it, because it's treacherous. I see a lot of times where documents are drafted really poorly, and so you end up with this whole meeting of the minds dispute. You end up with, well, my broker told me X, Y, Z, and this is what ended up happening. And if you just had a clear document trail, you probably wouldn't have had that dispute in the first place.
Disclosure.
Now, this is the second problem. And this one, and I cannot recommend anyone enter into this sort of transaction. How many of you have ever done an all-inclusive trust deed? Don't do it. Please don't do them. Let me tell you why. These are set up for failure. They're set up for failure. They're so dangerous. So all-inclusive trust deeds, for those of you that don't enter into them commonly, and this is why it's going to be, and I think these are going to become much more relevant in the upcoming years here because interest is so low. All-inclusive trust deeds work in this fashion. Kind of similar circumstance. Borrower generally doesn't qualify for traditional financing, but seller doesn't have enough equity in the property, so what they end up saying is, hey, look, I've got a first. It's a 4.5%. Interest rates are 8% now. Hey, all we'll do what's called a wraparound mortgage. We'll enter into a second trust deed in which the seller is the lender, and you pay the seller enough to pay both the all-inclusive trust deed portion, which is the underlying note. You pay that monthly amount plus some small difference directly towards the seller, right? And it sounds great. It's like, you pay the seller goes and pays the bank, everyone's happy. But there's a huge flaw with this concept. One, and there's a huge reason for this. How many of you have read, so all loan documents on any residential property for consumers uses what's called the Fannie Mae deed of trust, right? It's a form prescribed, everyone uses it, it's the only way you can sell a document on the secondary market, right? That document states that a transfer of ownership is a default under the loan. right? And a lot of people say, what big deal? You're telling me if I keep paying the first, that they're going to care that the property transferred? Yes, they do. And what happens is, you've now just transferred the property, but the bank then catches on to the fact there's a transfer, and now there's a default. And now there's a huge problem, because two things just occurred. One, the seller is in hot water, because you transferred the property when you didn't have the legal right to do so. And two, the buyer can now get kicked out of the property for it, right? And so you've got two very unhappy parties, and the only way to fix that situation from the lender standpoint is, hey, seller, they have to convey property back to you. And like that's gonna work out, a year after they're living in the property. So don't worry about it. Let's just unwind this whole thing, right? And so and the bigger problem you're gonna run into is a purchase and sale transaction should be that. It should be kind of, we come together, we deal with each other briefly, we walk away, and you get to enjoy your home, and I get to walk away with my money. But the problem with an all-inclusive trust deed is you've now set up two parties that now have to be friends with each other or become enemies with each other. And what happens is your seller is going to be upset with you, because what ends up happening is, let's just, this is another legal example that we actually had to work with as a law firm. It's 2 years, we did a 2-year balloon note. It was an AITD, right, with a 2-year balloon. Concept was, seller can't get financing right now, or sorry, buyer can't get financing right now. They'll get financing 2 years, the market will go up, your traditional reasons why it's going to work out. But what actually ends up happening in this situation, right? So now 2 years later, the note balloons. And the seller says, hey, I don't want to be part of this anymore. Just, go refinance, right? Refinance or sell the property. And the buyer says, no, this is my home. I'm not going anywhere, right? And the buyer even gets smarter than that. He says, you know what? I'm sick of paying you more than what I know what your note amount is. I get the statement still at the house. I'm just going to start paying the first lender, right? And so they start doing that. Seller comes to me and he says, hey, my note balloon, what do I do? And I say, well, you foreclose. You're a lender like anyone else. You go foreclose on the note, right? We do that, and what do you think happens? Seller gets sued, of course, right? And so then now you've got this issue. Seller is still liable to the first lender, right? So what happens when the buyer stops paying them? That's the seller's note. That's his credit that just got destroyed, right? He's the one that's now facing a foreclosure, even though he lives in a different property at that point, right? And on top of that, this is just your average guy. So this particular seller has his own he bought another home after that, so now he's carrying 2 mortgages just to stay current, right? All the while he's getting sued by the buyer, right? That's what happens in an AITD situation. That's why you can't do them, because, and guess what? Guess who everyone wants to sue right now? The realtor. Right. He told me 2 years I would get out of this. Whatever. I get it. The problem is an ounce of prevention. And here's the thing too, is what ended up happening is this is how they document the transaction. The seller's realtor went into escrow and said, just provide me with an AITD note. And I think that escrow serve a fantastic function. They, as a law firm, I really appreciate what they do. The one thing I have a problem with them doing is drafting legal documents. Because you have to know consequences. You have to understand the meaning and significance of what you're entering into. Because if you don't, what's the problem you end up with? You have a failure to have a meeting of the minds, right? And you need to have both parties understand what they're getting themselves into. And so, this document that I'm looking at, it's a 1-page note. It doesn't address anything, right? The smallest note I've ever drafted is 9 pages long. And it's not because I love being verbose, it's because I think of every single thing that could go wrong in the transaction, and that's my employer job. Everyone, why people, I think, have a hard time dealing with attorneys? We're negative. We're so negative. And the only reason we're negative is because I see terrible things every day, and I'm just trying to prevent them. And if I'm doing a good job, that means you never have to see me again. And the only time I'm doing a bad job is when someone says, hey, I don't quite understand what this clause means, right? I've done something wrong in my drafting, but at least I can understand what I'm doing when I'm doing it. So my only 2 points today, seller carrybacks, if you're gonna do them, okay, just make sure you go see attorneys. And I'm saying as a broker, you should make sure you see an attorney. And what they should do is make sure each side is represented. It's not very expensive to do these sorts of things. And it's one of those concepts where an ounce of prevention, right, it goes a long way. Because that $1,000 you spent for your attorney on the front end, prevented you from getting sued on the back end. And so, make sure that, and my only other takeaway from this whole thing is make sure that you represent properly. And what that means is be very cautious about your emails, right? Everything that you send via email is an exhibit in a lawsuit, right? So think about that prior to sending them. Be kind in your emails. Speak highly in your emails. Make sure and just be professional. I mean, that's for your own goodness, right? But remember that everything you write is going to be an attachment, right? And beyond that, remember everything you write is going to be used against you. And so, I can give you my own example of what happened to me. I actually applied for a home loan, and the loan originator told me, "Don't worry about it. I've got this deal that's going to come through. Our home didn't appraise for the value that we needed it to." He said, "Don't worry, I'm going to get a second appraisal done for you." I said, "Great, fantastic." Second appraisal came in on the money. We were great, and we took about 2 weeks. And I'm wondering what's going on. I had a great rate lock. Everything was fantastic. And the day before I had to lift my contingencies, the loan originator tells me, "Hey, good news, the second appraisal went through. Bad news, I had to go to a different lender." And since I had to go to a different lender, I had to lock in at today's rates. And the bad news, it's almost 1% higher. This was back in May of last year, which a lot of you I'm sure will remember that time period, right? Well, the problem for him is I had representations all throughout my emails. It's not my problem. It's your problem. They had to eat it, right? And all it took was just shooting an email back at him. If you recall, this email from May 15th, 2013 states the following, in which you told me the second appraisal would go to the same lender. What you're telling me today is that it's not going to the same lender. This is not my issue. I will sue you for the damages that you cause if you don't remedy this yourself. But that goes to the point. Make sure, and this sort of thing I see all the time. We're very trigger happy with that email. Really, we get upset, we get emotional, we get whatever it may be. We don't think through what we're stating in that email and the repercussions of what's going to happen, because 2 years later is when I'm going to see that email pop up again. And that's where we're going to have an issue. So, sorry to be so negative. It's kind of what my job is. But other than that,